Chairperson Dozier. Committee member, I'm sorry.
Here.
Marquez.
Here.
Harmer. Here. Loaiza.
Here.
And Atkinson.
Here. I can't see my agenda, but let's go for it.
Okay, so committee members, chair, the item was to review sections 5 through 8, which is encompasses city manager, departments, and employees' financial procedures and elections. So in anticipation of your discussion this afternoon, we prepared for you the matrix that was included with the agenda, which hopefully you found it helpful. And what we did was able to make a comparison of Shafter's charter and the different categories that we have, and then try to make a comparison to what the other cities had in terms of language. So at this point, we're prepared to help you with that, or if there's you as a committee want to just lead the discussion yourselves in those different categories. So for example, on the city manager under appointment, we identified the manner in which the city manager is appointed here in Shafter, the manner in which the city manager is dismissed, the roles and functions of the city manager, and then as you saw, we made a comparison into how the other cities do it and how they appoint and how they use treat the city manager in these other categories as well. So it's your prerogative, Chair.
Yeah, I think just keep going through it like we've been going.
Okay. So at this time, I'm going to have Yasmina walk us through. She's the one who prepared the matrix and did the comparison analysis of the different categories. So with that, Yasmina.
Good evening, Charter Committee. Tonight we are going to go over, we're going to start with section number Article 5, City Manager. And if you look on the matrix that was provided to you, we start with the cities that we went through on the last meeting. We provided the charters for several cities. I think it was about 8. In this matrix, we included Tulare and Visalia. They're in the valley. We hope that was a little bit helpful to you. If you see here in Shafter, the city manager position is appointed by the city council by employment agreement, and it is also a council manager form of government. The dismissal is, and if you guys would like me to, if there's specific sections that you would like to go through, we can just go through those or just go through each one. It's completely up to you, but what I have here is just the dismissal, the powers and duties, and the absence or disability. So again, for the appointment, we just went over that, and the dismissal is the city manager may be suspended or terminated only by resolution approved by the majority of the council. And the dismissal during the period of 120 days immediately following the date of installation of any new person newly elected to the council at a regular meeting, or any new person newly appointed to the council shall take no action, whether immediate or prospective, to remove, suspend, or request the resignation of the city manager. So that would mean basically
6 months.
Yes, 6 months after the election. And the reference, I put the section on there for you guys.
Just really quick, Yasmina, correction, 120, so it'd be 4 months, not the 6 months.
Did you say 180 or 120?
Oh, I'm sorry, it's 120.
Okay.
120, I'm sorry. So some of the powers and duties are very similar to, well, actually, let me go to Anaheim. Let's just go through section of dismissal. So Anaheim says the city manager shall not be removed from office during or within a period of 90 days after the municipal election. So theirs is 90 days while Chapter's is 120 days. And for Hayward is they are removed by affirmative votes or of no less than 4 members of the council. And I put their section. Their council did, excuse me, their charter did not specify the number of dates. All the charters are different. I don't know if you're able to see that. In Irvine's, their charter didn't specify that, but they do have an
We need
ordinance.
to start making iced tea, huh?
Let me mute that person there. The ordinance is adopted by the council. Lancaster's charter didn't have that information in their charter. Neither did Palmdale, Riverside, or Santa Rosa, and that was just for the dismissal. San Bernardino did say, or did state, their charter did state that the mayor shall have the authority to suspend and discharge for cause the city manager subject to the laws of the state. And Visalia's did not have, did not state in their charter, and Tulare didn't as well. So is there anything that you guys would like to discuss in that section, or would you like me to move forward to powers and duties?
I have a question. Right now, what is the probationary period for the city manager after appointment? Is it the 4 months?
No, the city manager is at will. So when a city manager in any city is hired, they're considered at will. And so there's no probationary period for a city manager upon hiring. What at will means is that we work at the pleasure of the city council, that unless it's the clause here pertaining to an election, a city manager can be released at any time by city council. So there is no probationary period. So a city manager could get hired March 1, and if the council so chose 60 days later, 90 days later, or a year later to separate the city manager, then all it takes is a resolution as stated here in our charter. It would be a resolution approved by the majority of the council.
Okay, so the 120-day protection, does that, I mean, that basically is like a probationary period. Is that what it's saying?
No, correction, the 120 days. So what cities will do, because oftentimes elections can be political, and so to give a city manager an opportunity to work with new council members, is they'll put clauses like this in, whether it's in their charter or in their ordinances, that the city manager cannot be released 120 days or 90 days or 180 days following an election. And that's to give the city manager and that council an opportunity to see if they can work together. If at the end of that term, it's realized that the new council may decide to go in a different direction and have different leadership at the city manager helm, then the city manager could be terminated for no cause. And that's where severance payment comes in, because city managers do have an employment agreement. There's often a severance clause in there for termination without cause. So the 120-day period is only related to immediately following a general election of new council members being appointed to office,
Okay,
or elected to office.
Okay, thank you.
Yeah,
Second,
Chapter has a contract with the city manager. Isn't that correct?
Yes, correct.
Yeah.
And I mean, it's a standard practice in the industry, whether you're a charter city or a general law city. City managers in the profession, we all have employment agreements. That's our only protection, because we are at will. And we work basically at the will of the city council, and city council has the discretion to appoint their city manager, any city manager that they deem that they want.
Correct. Any other comments on that area?
I just would like to say that I understand. I read through the other cities and what they have as far as dismissal goes. And I do like the fact that ours does state the date, 120 days, or time frame, I should say. I think it makes it kind of less political and a little bit more, shall you say, consistent as far as governance. So I'm glad there's a minimum of 120 days. I would even consider raising that to 180 days, or something, 6 months from 4 months or whatever it may be. But so, yeah, but I mean, I know Anaheim had 90 days and I know the others may not specify as much, but because elections do come and go. But I think what's important for a city personally is just having consistency. And so, yeah, I think it's great that it's there.
Yeah, I don't want to be aligned with Anaheim too much because most of those guys are going to be in jail here pretty soon. They're under federal investigation. Okay, just move on to the next.
Just
item.
really quick, Chair, something about San Bernardino. It's a strong mayor. The mayor is elected at large. The city manager is appointed by the city council, but then they also have a city manager. I mean, a city attorney that's elected at large. So the dynamics in San Bernardino, to your point about Anaheim, I mean, San Bernardino has been known to have their own issues and turmoil as well. Going back to the comment about there was, I don't know, that was a proposal by a committee member to consider 180 days, but if a comment was made, I just want to make sure that we don't skip anything over here before moving on. Chair.
Is this the time we can change things or we're going to wait?
It's a time for discussion. I mean, this is the purpose to have that. So this is that area for you all to have discussion on each of these sections.
Is that something you'd like to do, is change it from 120 to 180 or something?
I think, sorry,
Speaking to me or who are you speaking to?
I think all of us.
All of
I think a 6-month period would be, I think that's a reasonable time. And it gives them the opportunity to, like you guys were mentioning, really build that relationship and kind of get on board with it. I know we've had some changes like here recently, but I don't know if there's been any issues prior to that. So I don't know if it's a matter of time or it just needed to be done. So, but I think I would vote on 6 months.
Okay.
Yeah, I think 6 months is a time frame that I would feel comfortable with and suggest, but 120 is fine as a minimum as well. If you guys want to keep it the same, I wouldn't go anything less than that. That's for sure. I just, me personally, I think it's hard getting adjusted to anything in the time frame of anything less than really 4 months. So.
Does the committee agree that we want to make a move to 180 instead of 120?
I am in total agreement with the 180 change because it gives, like Gerard was saying, 6 months for the new employee to adjust, to acclimate to the policy and procedures of the city. So I propose that we change it to 180.
Is that a motion?
Yes, I make a motion.
Second?
A second.
I just want to interject. This is Henry. I just want to clarify that we're not making any motions or taking any actions. It's kind of just an overview. And towards the end, once we do the final meeting, then we can actually take action, because the way the agenda is written today, it's only a management report. So we're the discussion and everything's good, but we can't take any action.
Okay, then put it in the notes that the committee is committed to changing it. So when we get to there, it's on that.
And we don't forget.
Yeah.
Because there's a lot.
Correct.
No,
Thank
exactly.
Yeah, we're taking.
Because we've gone through several chapters now, and this is the first thing that's actually come up that, we think needs to be changed so far. So that's good.
Chair and committee members, with regards to appointment, anything you see that would need to be considered here? If not, we would leave it the same, which is appointed by city council by employment agreement, continue to remain council manager, form of government.
Yeah, no, I agree with that. I think the staff needs to have one boss, and that's the city manager. And the city manager has to have the board or the council. And if they need something done or want something done, they tell you and you direct the staff. You can't have 6 or 8 bosses telling you what to do. That's impossible.
Mhm.
Okay. With regards to the powers and duties, anything that stands out when you compare Shafters to the other cities?
I don't know. I'm fine with the way it is.
I have a question on section A, appointment of employees, where it says like to remove and discipline. Is that something that like you confer with like your HR department and like the attorney, or do you just make that decision and then let the chips fall where they may? I would assume it'd be a little more organized rather than just a decision.
Yeah, so we're still on city manager. Did you jump over to section 6?
No, it's section 5, 03, powers and duties, section A, appointment of employees.
Okay. I'm trying to get there. My font is a little slow.
It says appoint, remove, and discipline all employees of the city pursuant to requirements set out in this chapter and an ordinance establishing a merit system of appointment and employment.
Yes, so department directors are at-will employees, similar to the city manager. So this is Shafter's model. Department directors are treated as at-will employees. They also have employment agreements that's executed between the city manager and that department head. And like the city manager's contract, it's modeled after that the director is at will. So I'm breaking it down. So you got directors, managers, and supervisors, and then you have line staff. Okay. So directors are at will. They have employment agreements that they can be terminated with or without cause. Managers, supervisors, we have a progressive discipline pursuant to our personnel rules and regs that, depending on the type of violation against the city policy or misconduct or dishonesty, whatever the case may be, are disciplined. And then line staff, same thing. It's a progressive and depends. If we have a union involved, which right now we only have 2 unions, and that's our police officers union and SEIU, which is basically our public works employees comprise SEIU. And both of those agreements with the unions dictate the manner in which we discipline employees. The other line staff that are non-union, again, it's a progressive discipline that I don't supervise. The city manager doesn't supervise directly the line staff. The only direct employees, direct reports are the directors. So if a director gets themselves into trouble, performance issues, or it can be, or the city manager chooses to go a different direction with that director, then they're at will. A manager supervisor will have progressive discipline pursuant to our rules and regs that the department director supervises. So that department director would be the one to initiate, whether it's termination, suspension, or whatever the disciplinary action may be. And to that extent, then they serve the notice, and ultimately the city manager would be what's called the hearing officer, and they would either uphold or change the proposed discipline. And then ultimately the city council serves as the appeal board, meaning if a city manager upholds it, the director's proposed discipline, the city manager upholds it in the Scali hearing, then that employee has the opportunity to appeal to the city council, and then ultimately the city council serves as the final decision maker, whether to uphold or modify the discipline or completely not move forward with the discipline. So that's how the breakdown in terms of the hierarchy of the city manager. The city manager is the chief personnel officer for the city. So the city manager signs off on all discipline matters, on all hiring. So whenever new police officers hired, for example, then the city manager signs off on the hiring letter. We sign off on the conditional offer and the actual offer letter. And then same thing, if a probationary employee, say a police officer, doesn't make field training, doesn't pass their probationary period, they're released, or an employee in public works, then the city manager signs off on that release.
And then same for like grievances or any kind of issues, that all goes back to the city manager as well.
Correct. Yes. And like I said, the MOUs, memorandums of understanding with both the Shafter Police Officers Association and SEIU, their MOUs spell out the manner in which those grievances are filed. And then our personnel rules and reg for the non-union employees also have that process as well.
Okay, and that's SEIU 521?
I believe, yes.
Okay. Thank you.
Thank you.
And then the other category was absence or disability. Anything in that area that stands out differently? So basically here for Shafter is if the city manager is going to be absent or disabled, they have to submit a writing designating an acting city manager on the occasion of city to be absent for longer than 48 hours. And the city council should designate an acting city manager in the event of disability or at the request of the city manager. So I'll give you a quick example, real world example. I recently had back surgery at the end of January. And so I was completely out of commission, obviously during the procedure itself, and then subsequent quick weeks following it. And so under that circumstance, I did appoint an acting city manager. And I notified the city council in writing of my absence and my temporary disability and the fact that I was appointing an acting city manager.
And that worked fine. That system worked fine. And under
Yes.
those
Yes.
circumstances, yeah.
All right, I have a question on section, the one right above it where it talks about restrictions. Is that more in regards to like a conflict of interest? Yeah, that's it.
Yes. Yeah.
Okay. So basically you would not be able to make any decisions that again would benefit, because you're the city manager,
Correct.
that would benefit you financially or your family, and that's all part of the restrictions.
So engaging in incompatible business occupational activities. For example, I couldn't consult for a client that's also doing business with the city while I'm the city manager.
Mhm.
That's an example of that. I couldn't be operating a business in the city that would be competing in itself with kind of the role of the city manager. So in addition to this language here, there's language in the employment agreement that further puts restrictions or parameters of what a city manager can and can't do in terms of work outside. Oftentimes city managers may be asked to lecture at a conference or seminar, something like that. You know, it's not seen as an issue, but if I'm going to start consulting, or the city manager is going to start doing consulting and taking on clients in local government, oftentimes, you know, that may be frowned upon, you know. So those are examples, but it's common for city managers to lecture at seminars as practitioners of the industry. We may provide again lecture. Some city managers may even be professors or adjunct professors at junior colleges or universities, or guest speakers. So things like that are permitted, but to this, yes, we do have restrictions to make sure that we don't get ourselves into conflicts.
Okay.
Cool. Any other questions? Moving on.
Okay, so just really quick, we'll make a note on the 180 days to bring that back. And if nothing further on this section, move on to departments and employees. So,
Yes.
okay. Yeah, it's me if you want to walk us through really quick on this.
Sure. In Shafter City Charter, we see that under authority to create department heads and departments, the city manager has recommendation, or he makes recommendation, and council adopts it by ordinance. And as you can see, all the city charters that we reviewed for you, they didn't specify the creation of department heads and departments. And then moving forward, if I can move forward, the department head appointments and removals, the city manager has that authority in chapter, and that's in section A and B here. And also the other cities that we did go through, they do specify that in Anaheim, the city manager has the authority as well as Hayward. And in Lancaster, the city manager is to confer with the mayor prior to conducting a final interview or making appointment of a department head. Palmdale does not specify, and in Riverside, the city manager has the authority to appoint department heads, except for the elected positions, which is the city attorney or city clerk. And then in Santa Rosa, the city manager has the authority, and San Bernardino, I'm sorry, I forgot to put that information there. And Visalia, the city manager has the authority subject to council approval. And also in Tulare, the city manager has that authority.
So Gabriel, how does it work in chapter? Let's say you're going to hire a new department head and you put out the headhunter group list or you advertise for it, and then you get, say, 3 or 4 people that seem to be qualified for that. Do you interview them just yourself, or do you get is there council people involved in that, or your HR division, or how does that work?
Certainly. So we do follow a process, and typically you'll have, so for one, a little bit of background about Chapter. Chapter is, as a city, we have a lot of tenured department heads, and I think with the exception of probably a police chief and some retirements, most department heads probably been with the city average of between 12 and 15 years. So turnover at the department head level has been very limited. But I'll give you an example of best practice in the industry is a city will recruit 2 things. They can either go with a recruiting firm or they can do the recruitment themselves. Whether it's a headhunting firm or in-house, obviously they got to meet minimum qualifications. You advertise, they apply. You usually will have a panel of professionals in the industry. So if you're hiring a planning director, you might have a panel of professional planning directors that will interview, and then they'll give a recommendation. In the past, I typically will also involve my department heads to conduct interviews to get feedback from them. And then ultimately the city manager conducts the final interview of the finalists, whether that's 2 or 3 or even 1. But that's a typical process that takes place in the recruitment. Chapter also, the city manager also has the discretion to appoint. So, they have a strong candidate, they can, recruit and make the appointment.
Cool. Thank you.
So there's some examples of how Chapter does it.
Excellent. Thank you.
Anything on the category 1 with regards to authority to create departments and department heads? And obviously Chapters has one that has the section here that city manager recommends and city council adopts by ordinance. All the other cities in comparison didn't have anything that speaks to that. Anything here of the committee leave the same? Any consideration, any discussion of you want to consider something different?
Now, these contract agreements for employment, are they an evergreen or contract, or is it a specific date, or do you re-up the contract 6 months before the end, or does it roll over? What kind of cushion is in there?
So here in Chapter, they're not evergreen. So including myself, the city manager, and the department heads, they tend to be for a term. So my employment agreement was a 3-year term. And for example, mine expires March of 2023. Department directors, I think the city has done between 3 years and 4-year agreements, but it's not evergreen clause.
So like, let's take you for example. In 23, your current contract is going to be expiring. So when does the city renew that or tell you they're not going to renew that? Is that 3 months ahead or 6 months ahead? Or, I mean, it's not like tomorrow we're not renewing or we're this or that. You need more lead time than that, I guess is what I'm getting at.
Right. So, Yasmin, I saw you screening back up. You're going to point something out?
Yes, I'm almost certain it's on here, but let me search for it off the screen.
Okay. Well, as you're looking at, let's go on to the next one.
All right. So then the other category is department head appointments and removals.
I think we're on the city clerk section now.
Correct. I just wanted to make sure, I'm asking the committee if there's anything on this section that they would want to leave alone or anything that stands out that they see that they want to consider something different.
I just wanted to understand how the contracts are renewed, what kind of time frame that usually is.
So department heads, since those come to the city manager, those could be tied as part of the performance evaluation in terms of when the performance evaluation is conducted and concluded, then that topic may be taken up. Or, at a professional courtesy, obviously a department head is going to want to know that they're going to stay employed because once you get to that executive level, it's not like you can turn around and become a department head the next day or a city manager the next day, even though right now there's a ton of jobs and openings. And so typically city manager will sit down with that department head. The city manager will keep a calendar of when those contracts are due and to expire. And they'll sit down with the department head in terms of whether we renew that agreement. Usually it's at least with a minimum, 5 to 6 month lead time.
Yeah, no, that's fine.
To do that. I don't know what Shafter's done at the city manager level. I think my contract has some verbiage in there about, at least certain amount of time to let me know the council is not going to renew the contract. Because again, it's not like even the city manager, even though there's a lot of openings right now, I mean, we got to go through a process because cities will have a recruitment, they'll open it up, they got a due date, they'll screen applicants, you got to interview on and so forth, and it could be 3-4 months later. So that's typically how it's done.
Thank you. Next, city clerk.
So in Shafter's charter, the city clerk if the charter states that the city clerk is a department head, and so the department head obviously works for the city manager. And in other cities, as in Hayward, Anaheim, and Irvine, the city clerk is appointed by the city council. And that's what we found in their charter. Lancaster and Palmdale, it did not state that in their charter. In Riverside, the city clerk is appointed by the city council. In Santa Rosa, the city clerk is appointed by the city manager. In San Bernardino, the city clerk is an elected position. And in Visalia and Tulare, the city clerk is appointed by the city council, according to their charter.
Thank you. Any comments or questions on that part? City attorney.
Okay, so city attorney in Shafter, In their charter, it states that the city attorney shall be a department head, and the city attorney advises the council, individual council members, and the city manager and assistants or department heads regarding the laws relating to city affairs. In Anaheim, the city attorney is appointed by the city council and will represent and advise city council and all of its officers, the same as Hayward and Irvine. That is listed in their charter. Lancaster and Palmdale, it does not state in their charter. In Riverside, the city attorney is appointed by the city council and the same as Santa Rosa, and they will represent and advise the city council and all of its officers. In San Bernardino, the city attorney is an elected position according to their charter. And in Visalia's charter did not state, and in Tulare, it states that they are appointed to the city by the city council, and they represent and advise the city council and its officers.
Hi, this is Henry again. I just want to clarify that San Bernardino has moved away from their elected city attorney position, and now it's appointed by the city council.
Thank you, Henry.
So in Shafter's case, the attorneys work for the city manager. Is that correct?
It's,
Because they're a department head?
yes, under that structure, then yeah, basically they would basically answer to the city manager.
Cool.
So in these other cities, where it says appointed by the city council, so in most cities, the two appointed positions for a city council that they have oversight is the city manager and the city attorney. And so where you see the rest of the cities where it says appointed by the city council, appointed by the city, that's what it's referring to.
Yep. No, I think it's
I
the
have
way
a
it should be.
concern with that. I'm sorry.
So go ahead.
I have a concern with the city attorney being a subordinate of the city manager. You know, I agree with Riverside, Santa Rosa, Tulare, where the attorney is appointed by the city council, and he should answer to the city council and not have the city manager as his supervisor, because the attorney represents the entire city. And if the attorney has a disagreement with the city manager or doesn't agree with something that the manager is doing, he can't really speak up because he could be terminated for any reason. So by the attorney being appointed by the city council, then he works with the council, but he also works alongside the manager, but as a peer-to-peer, not as a subordinate of the city manager. And I know in Shafter, it's the attorney is under the city manager.
Yeah, well, trust me, BB&K wouldn't hesitate to speak up if there was some kind of conflict.
Okay.
And every council meeting, you know, I don't think the city attorney doesn't come to the council meeting physically. Does he do online, or if there's something that needs legal opinion, they show up, or because you don't want to run up a big bill if you don't have anything significant going on.
So best practice is, when I say best practice, that's kind of like industry, you know, what you see commonly in the industry. So what you see in the city attorney is most city attorneys will be present during the council meeting. And so to avoid, to your comment, Chair Atkinson, about running up a legal bill, usually most cities will have their city attorney on a retainer, monthly retainer, which will stipulate that they have to do routine ministerial tasks like resolutions, review agendas, anything that pertains to any legal review. They'll participate at council meetings.
So that's
one,
in their they're in their contract then.
yeah.
Okay.
So that's a best practice in the industry. That's one way cities manage that. that cost. And in that retainer fee is included a number of different things. And then anything specialized, land transaction or a personnel matter or something, or environmental review, you need an environmental attorney involved. All that is charged separate than the retainer. And that's typically how most cities do it.
I also agree with the statement, because you don't, what happens when the attorney is trying to do their job and protect, the council, but if the city manager is his boss and says, I don't want you to bring this up, but if he's being paid to represent the city, the best interest, and the city council, and he doesn't bring something up, and then we find out later on down the road or whatever, is that a grievance for the city council in regards to that attorney, because he didn't do what he's hired to do, because let's say the city manager says, we are not going to discuss that. I don't want that on the roster. I don't want that to be discussed, or whatever the situation is. I mean, it should really be separate. I don't think that you can't work hand in hand, but it should not be where the city council is his boss, because I think that creates a conflict.
Well, any councilman can put whatever they want discussed on the agenda.
Yeah, but if the city council, if the city manager is the attorney's, direct supervisor, and he tells him not to, what stops him from doing it, or what causes him to do it?
Because the council is the boss of the city manager. And if they want to discuss something, they're going to ask the opinion of the attorney. But you can't have 5 or 6 guys telling the attorney what to do. That's not realistic, I don't think.
Dennis, where does it state that the city attorney is under the council?
No, he didn't say that. He said the city.
No, it's under the city manager,
Okay,
and the city manager is under the council.
Correct.
yes.
And every agenda has a comment or a place for new business, or we want this or we want that. And you just mention it, and the staff is supposed to work on that for the next meeting. And if it's a legal issue, the council is directing the city manager to do X, Y, and Z, and he's going to tell the legal guy he's got to do it. You can't tell the legal guy, no, you can't comment on that, because that the council specifically asked for it.
Gabriel, do you have any input on that as far as what's actually written?
I think what I'm understanding you say is it's not just the city attorney, but that can be applicable to any department head. That because what I'm understanding you say, and I'm going to apply it more generally, not just city attorney, but any department head. But what I'm understanding you say is that because the department director is a direct report of the city manager. Basically, the city manager is the boss of that individual. That the city manager can have influence on that department head of what direction they may be given in terms of advice. I can tell you, the city attorneys, they're bound ethically, and as part of their licensing as an attorney, their own legal obligation is that they have to advise the city council anything that's illegal, immoral, or unethical, and they're there to advise the city council in that regard. So if I'm misunderstanding you in terms of what you're trying to convey, then you can let me know, but that's kind of what I'm understanding. But I would say that influence could be applicable not just to city attorney, but any department head.
Yes, I guess and maybe, I'm sorry, I don't remember the lady's name that made the comment first.
Susie.
So I think what we're kind of saying is, yes, I understand what you're saying, Gabriel, where you are in charge of all of these other department heads. So if there was a problem there, you could, resolve it, or they could maybe not necessarily go to you. They could go around to the city council and say, hey, I'm having this problem. But are they overstepping the chain of command in that way? So what we're saying is, if there is a problem let's say between you and the attorney, if you're telling him, I don't want this discussed, or don't bring this to the table, or whatever the situation is, even though he's legally bound and ethically bound to bring that to the city council, could he not, because you're telling him not to? Is that a better question for clarification purposes?
I suppose that we're generalizing here for the record, and where this is being recorded, that's not what takes place at Shafter.
Okay,
But just for the record, in general terms, I mean, that yes, that type of influence could take place. But like I said, under any department head, that can be applicable in that situation too.
I tell you,
I get.
Kern County had this exact same thing, is that the county's general counsel got between a supervisor and a department head. And that's where the problem came. And she could not, while she was representing the county, she couldn't do this or she couldn't do that. She resigned because her ethical rules that she has to operate under in the legal department, she didn't have any option to not do this or not do that. And you can't say what the deal was. So you take it to your grave, or you give up your law license. You know, it's pretty, they're under some pretty strict rules, the legal guys.
If I may, just a point of clarification, myself and staff, particularly the city manager in this case, it's not an individual council member that can direct the city manager what to do. We don't. So in order to protect that from occurring, or to prevent that from occurring, the city council, the majority of the council has to give direction during a regular meeting to the city manager of direction. So the individual council member wanted something done, then it's not carried out, because it has to be a council member can bring it up to their peers, to the council, and say, hey, I'd like to bring a policy forward to address illegal parking of semi trucks and residential. That's an example, right? Then the rest of the council can either say yes or no, and it has to be a majority of that in order for the council to give direction to the city manager. So I just want to point that out, that individual council members, per the charter, are not allowed, or there's protections to prevent that from happening, and it's only during a regular meeting of the council with the majority of the council giving direction to the city manager.
But any councilman can put it on the agenda for the next meeting so that they can discuss whatever it is that one of them likes or doesn't like.
So most cities will have what their council norms, in which they agree how matters are brought forward, because otherwise you can get 5 individual council members bringing their own specific items. So the city council norms that a council adopts, which is on their own little their rules, if you will, in that they agree on how those things will be forward. Some examples may be that it's one council member and one of the council member brings it up. Others is, you got to bring it to the full council and they decide. It can be, a council member in consultation with the city manager. So there's different instances like that.
Well,
The way it should be.
what I was trying to convey is the city attorney should not be a department head, because it should only answer to the council and not just to the city manager. This way, there's no conflict if the manager is in question. And just for the record, I don't even know the city manager, so it's not a personal attack on you, city manager. I'm just
None taken.
future, because city of Shafter is going to grow. We both mentioned that in our first meeting. We foresee at least 10,000 more people. So that's what I'm looking at in the future, where the city manager shouldn't be, the city attorney should not be a department head. They should not just, they need to protect the entire city. and not worry about whether their contract's going to be renewed because they've had a conflict with the manager.
If I may, just since, we're talking here, it's discussion. Oftentimes in the industry, we'll see where a city attorney and the city manager are the two appointed employees of the city council. The reverse could happen, not the reverse, but the same could be said in instances of where a city council wants to go in a different direction. And so your example in which the city manager and the city attorney have a conflict, and because the city attorney is a department head and a subordinate to the city manager, that city attorney can be in jeopardy of, their position. The same could be true when it's the city council. They're the immediate appointing board of the city attorney. Just like a city manager, if a city council wishes to go in a different direction, they basically release the city manager. And similarly, the same could be said about a city attorney. If a city council wishes to go in a different direction for whatever reason, maybe because, a council wanted to go one direction in a business transaction and the city attorney advised them that that was probably not the best approach, or there were some legal concerns, but the council may have insisted. They said, well, we'll just get a different attorney. And that city attorney is released and a new attorney is brought in. So it's not just whether it's a department head subordinate to the city manager. The same could be said if it's an appointed position by the city council, because we serve the city manager position and the city attorney serve at the will of the council.
That's something that I think is a good point. When we're, I don't know, this is my opinion, but when we're doing this, we're looking at this, we want to, or for myself, I'll speak for myself, I want to do it to where it's makes sense, it's simple, it's easy to follow, and there's tremendous amount of transparency. And how do you set up a charter to where you find the least amount of holes like Swiss cheese or corruption or possible conflict or whatever you want to call it? And so I think everyone that commented on this subject have brought up some good points on both sides of it. But so I don't know if somebody, just to move on, if somebody wants to, put this in the notes or whatever, and we can just discuss it. I know, no motions can be made at the moment, nothing like that, but I'm just saying if you guys want, we can look at it later. But I think that's a very good point, is I could see how that could happen on both sides, whether it be the city council wants to go in a different direction and tell the city manager bye-bye, or vice versa. Also, how a city manager might and a city attorney might have a conflict also. And so nothing is perfect. What I think our job is just to make recommendations to the city council of, what we think would be a good idea, and kind of let them take it from there.
Yeah, we can put that in the notes. That's our second note.
So I'm understanding to bring this back to the committee as further discussion.
Yes.
Thumbs up by the rest of the committee.
I would agree with it.
I agree.
Okay, next,
I
what is
think
it?
the next
Personnel?
section,
Personnel?
financial procedures.
Financial. Oh, I thought we were a personnel system. We passed that already? I'm on the
Yes,
wrong
Mina,
page.
help me out here.
Can go over.
Yeah.
We didn't create this in the
Oh.
charter, but we can definitely go over.
I'm fine going with the financials if everybody else is.
If there was something specific that you wanted to discuss in the personnel system in the section 6.404, we
I
can
did-
go it
I
over.
didn't turn the page.
Okay, so move on to financial procedures.
Yes.
Sorry, on that section, is that more of like for their evaluations and like promotions?
On the personnel piece,
Yes.
merit system, non-discrimination, personal ordinances, I think that's all in the union contracts or the Shafter HR book, how all those things work.
Right,
Well-
so, go ahead.
No, I was going to ask, was there a specific question? I think your question, about my understanding, is the personnel roles. What is it covered? Basically, this section just on a high level states the manner in which the city will hire with its applying a merit system. Yeah, it will not be discriminatory, especially in today's environment. And there's a personnel ordinance that creates the personnel system, and then it spells out the manner in which what it will be included. So I can tell you that the city does have personnel rules and regs that are adopted by the city council. We have other policies like zero tolerance for sexual harassment, drugs in the workplace, violence in the workplace. We have a resolution for non-represented employees that, much like the two labor groups, SPOA and SEIU, stipulates all the different categories of how often they'll pay, vacation accrual, sick leave, all the work conditions that follow basically the same format as the MOU with SPOA and SEIU, and then grievance and such, disciplinary action of how that's approached. And that's done by resolution and ordinance, not necessarily in the charter. That's what section C talks about, the personnel ordinance.
Are there any other questions on that?
No, so sorry, what you were saying is, yes, for hiring and then for lateral moves within the city. I like this, so this is good for me.
Yes, we just a side note, Shafter has a history of promoting from within. And like I said, I think we have a very long, a group of employees that are long tenured, and they enjoy working here. I mean, I can tell you that at the executive level, we've only had one retirement in almost 3 years. And prior to that, I think it was probably only one other department head. But aside from probably the police chief, who I think has been with us 6 years, due to another retirement before that, all the other department directors have been very consistent in terms of their tenure. And then promotions from within the ranks is usually done within the city.
Anything else?
No.
Financial procedures?
Okay, Yasmina.
So the financial procedures, you can tell in our charter, was very lengthy. And this is probably the biggest section that I provided to you guys, to the committee, excuse me. So with Shafter, we can start off with the property tax limits. It's pretty much everything that's listed in the charter, but we may not levy, or Shafter, excuse me, may not levy a property tax for general municipal purposes in excess of a maximum rate applicable to the city. Shafter may establish separate taxing areas within the city for the levy of a tax in excess of such maximum rate. And procedure and authority for the assessment, levy, and collection of taxes may be prescribed by ordinance. So if you see through the cities within the charters that we provided, they're very similar to what Shafter has. Anaheim says that their procedure for the assessment is to levy collection of taxes upon property taxable for municipal purposes shall be prescribed by ordinance of the city council. And if the council fails to fix the rate and levy taxes, the rate for the next preceding fiscal year shall there be automatically adopted. So in your section, I put all the reference sections. You can go on there. In Hayward, The city manager submits to the council an estimate of the amount of income from fines, licenses, and other sources of revenue. Irvine's is similar to Shafters, where they shall not levy property for the general municipal purposes in excess of the maximum rate applicable to the city on the effective date of this charter. Lancaster and Palmdale's charter does not specify. In Riverside, they shall not levy a property tax for municipal purposes in excess of $1 annually on each $100 of the assessed value of the taxable property in the city. In Santa Rosa and San Bernardino, it didn't specify in their charter. In Visalia, the total property tax for 1 year shall not exceed 1% of the assessed valuation unless a special tax to be authorized. And then in Tulare, it's by ordinance provided for the assessment, levy, and collection of taxes. The tax levy authorized by the council shall not exceed $1 upon each $100 of the assessed valuation of all real and personal property within the city. So it's very extensive. So if there's any questions on that, property tax limits that you'd like to discuss, or we can move on to the revenue.
Any comments or questions? Let's move on.
So in our revenues in the charter, it states that we maintain a revenue structure adequate to meet the city financial requirements for execution of the balanced programs determined by the council. And the revenue structure shall be balanced equitably between taxes, fees, and utility and enterprise charges and assessments. In Anaheim, Hayward, and Irvine, it didn't state their revenue structure in their charter. In Lancaster, it states that any revenues raised and collected by the city shall not be subject to subtraction, retention, attachment, withdrawal, or any other form of involuntary reduction by any other level of government. In Palmdale, it states that all revenues due to raised by the city shall remain within the city for appropriation solely by the city council. And in Riverside, it states the revenue of each public utility for each fiscal year shall be kept separate and apart from all other monies of the city by deposit in the appropriate revenue fund. Santa Rosa did not state. San Bernardino states city manager shall transmit to the mayor and common council, accompanied with the estimates and reports of each department of an estimate of the probable, financial necessities. And Visalia, it states accounts shall be kept for each public utility owned or operated by the city, distinct from other city accounts, and in such a manner as to show the true and complete financial results of the city ownership. And in Tulare, it states city manager shall submit to the council an estimate of revenue and expenditures for the ensuing year. Any questions on that?
I don't have any. Does anybody else have any questions or comments?
None. I'm good.
Okay, moving on.
Did you have a question? Sure.
I just had a question. What's the difference between kind of what we have here in Shafter versus or I guess not a question, what's the difference, but rather, I mean, what is the benefit, I'll ask it like that, for like what Palmdale put in, all revenues due to and are raised by the city shall remain within the city for appropriation solely by the city council. No such revenue shall be subject to subtraction, retention, attachment, withdrawal, or any other form of involuntary reduction by any other level of government. That's the city manager or the city attorney, kind of just curious.
Certainly. So typically when on a special tax revenue, it seems like some cities raise a 0.5 sales tax, a quarter tax. In that case, that it's basically saying that that revenue should stay within the city and not be tapped into by the state, for example. So historically, the cities have been from the state in the past, the state would borrow monies from cities when they had budget constraints. And one of the benefits when cities pass their own sales tax measures through a ballot measure, basically that money, not basically, but that those revenues stay designated for the city.
Thank you.
So without having had a legal review of this particular section for Lancaster, I would imagine that's what it's referring to.
I believe it was for Palmdale, but okay.
I mean, excuse me, Palmdale.
Thanks. My only question.
Any other questions? Moving on.
So in special funds in the chapter charter, it states that the by ordinance provide the annual budget to adequate provision for reserve accounts in each fund or special fund for emergencies, uninsured losses, fixed assess, replacement, utility and enterprise facility perpetual replacement. So in the annual budget, it shall identify and make adequate provision for any other such reserves. The annual financial report and budget shall be supported by the statements. Such special funds and accounts shall remain inviolate, for the purpose for which they were created. Anaheim, Irvine, Lancaster, Palmdale, Riverside did not state anything for special funds. Hayward's did. It states fees and charges for use of any on-street parking meters and existing off-street parking facilities, any revenue from which are pledged to secure the bonds. Santa Rosa did not state in their charter. San Bernardino, they're stated that they had specific funds. So they have a library fund, sewer fund, water fund, and any other, and such other funds as may be designated by ordinance and adopted by mayor and common council. And Visalia states special levies in addition to the above may be made annually in amounts not to exceed the limits hereinafter in the section, respectively on each $100 of the assessed value of the taxable property in the city.
Any questions or
So-
comments? Hearing none, we're moving on.
So, for annual review and chapters charter, it states that annually the council shall review the cost of all city services and set fees. It shall determine appropriate to recover cost thereof as it shall determine pursuant to the provisions of the state constitution and applicable state law. Anaheim, Hayward, Irvine, Lancaster, and Palmdale didn't state an annual review in their charter. Riverside's charter states to submit a complete audited comprehensive annual financial report, and that's also what I believe Shafter does as well. I don't think it's stated in this section. I think it's stated in a different section. Santa Rosa, the chief financial officer shall issue an annual financial report. San Bernardino is to prepare and submit the annual budget and keep the mayor and common council fully advised of the financial condition and needs of the city. Visalia shall annually cause to be made a report showing the financial results of the city ownership and operation, which report shall give the information specified in the section. And Tulare did not state any annual review.
Yasmin, I have a question.
Yes.
So the report that you're reviewing, you're comparing their charter with our charter, and then the report that you're getting from, is that something that they just post online?
So all the charters that I had they are available online, and we had them on file from work that City Manager Gonzalez had done in the past. So I did review their charters and our charters and made this as a comparable list, a matrix that hopefully it will be helpful to you. All the charters that were provided to you all, I believe this last meeting, and they are also online in that
Sorry.
packet.
No, my question is the report, the information that you're gathering, like as far as the results, that's your own data that you've collected?
Yes.
Okay, because I was gonna say that would be a great thing to attach to this, because then it makes sense, like, you know what I mean? Like exactly how you're doing it, that information attaches to section 703 or whatever it is. But if that's just like a separate report that we find online for the city of Shafter, that's fine. But I like that you did that. So thank you so much.
Yes, we made this for hopefully to be helpful to you, the committee.
Took you 10 minutes? Or
It's-
10 whole minutes, yes.
A little bit more than 10 minutes.
Chair, through you to Susie, are you referring to, was your question also related to the fee schedule report, or just the matrix work that was done?
Are you asking me?
Yes.
Oh, it was Cynthia. Yeah.
Oh, I'm
'cause
sorry, Cynthia.
So she's giving the comparison, but then she's giving like the end of the year summary for them. So I'm thinking that would be great, because that makes sense and it ties along with it. Because I will say one thing that I think would be very, very helpful, and this, I could probably bring this up later on too, is that prior to being asked to be on this committee, I never knew we had this charter. And I've gone to city council meetings where things have come up and people get really heated. As you know, people get very flustered, very, you know, they get in their feelings about what's going on. But if you go back to the charter and you go, oh, these are the guidelines, this is why they're doing this is why they're doing that, it makes sense. The minute that you go, hey, wait a minute, I have this charter and this part of that they're doing doesn't make sense, there's where we have the problem. So I think that having the city, you know, that all of the residents know this is something that we have, or even putting it out there for city council meetings after this is kind of approved and resolved, would probably solve a lot of conflict and questions and unnecessary drama during city council meetings.
Thank you for that.
Mhm.
Any other comments or questions? Moving on.
So moving on to the purchasing and contracting section in the charter. Shafter's charter states that it will provide a purchasing and contracting system assuring a maximum of competition for the lowest price consistent with a stated level of quality. And in the charter, it has public works determinations and bid procedures. I didn't list it in the matrix because quite frankly, it's a lot of information, but we can definitely go through it if you'd like to. We can go through each section. If not, I can move forward with the matrix.
Let's move forward.
Okay, so Anaheim's charter states that the city manager shall establish a centralized purchasing system for all city departments and agencies, except otherwise stated in this charter, in their charter, and the city manager shall recommend, make recommendations and the council shall adopt by ordinance. Hayward's states that the centralized purchasing system shall be established for all city departments, offices, and agencies. The city manager shall make recommendation and the council shall adopt the rules and regulations for the purchasing and contracting. And before making purchases of or contracts of supplies, materials, and equipment, they will have ample opportunity shall be given for competitive bidding. Where our states what our bidding procedure, I don't believe Hayward's had specifics. Irvine's states that the project involving an expenditure of more than 4,000 or such amount as may be prescribed by ordinance for the construction of public works shall be let by the council by contract to the lowest responsible bidder for the public, for responsible bidder, and for any public works determinations and procedures, we would refer to that section. Lancaster's charter did not have a purchasing and contracting section. Palmdale states that they have the power to establish standards, procedures, rules, and regulations related to the purchasing of goods, properties, and services. Riverside states that the city manager shall establish a centralized purchasing system for all departments and agencies, which the system shall be consistent with all other provisions of this charter. Santa Rosa states that the city officers and employees, the members of board and commissions, shall not be financially interested in any contract purchase or sale made by them in their official capacity or by any body or board of which they are members. San Bernardino's charter did not state a purchasing or contracting section. Visalia states that when they are making purchases for all the departments of the city, local merchants shall be giving preference, quality and prices being equal. And Tulare states that all public buildings work when the expenditure therefore shall exceed the sum established by a policy adopted by the city council shall be done by contract and shall be let to the lowest responsive bidder.
Any comments or questions? Moving on.
So the budgeting and accounting section in our charter, it states by ordinance to provide an integrated budget and financial management system. Each fund shall have a balanced budget, an annual budget and budget message by the city manager for the ensuing fiscal year shall be submitted on or before the first working day of the last month of the current fiscal year. Budget shall provide a complete financial plan for all city funds, agencies, and activities for the ensuing fiscal year. And the council shall adopt the annual budget by affirmative vote of a majority of its members on or before the last working day of the last month of the current fiscal year. And I've stated this section here. Anaheim's charter states that the city manager shall review the estimates, hold conferences with the respective department heads for the budget. The city manager shall submit a proposed budget 30 days prior to the beginning of each fiscal year, similar to Shafter's. They shall hold a public hearing on the proposed budget, which we do as well. And the council shall adopt the proposed budget. And I have listed in Shafter's matrix to refer to this section just because it has more information in the charter itself. Hayward and states that the city manager shall submit proposed budget at the beginning of each fiscal year. They hold a public hearing and they adopt the proposed budget. Irvine's shall submit proposed budget and message for the ensuing fiscal year. And the budget shall be adopted by the city council before the beginning of the fiscal year. Lancaster's charter did not state budget and accounting procedures. Palmdale states that they shall have the power to establish standards, procedures, rules, and regulations related to any public financing. Riverside's, they provide the budget annually and submit the budget to the council and be responsible for its administration after its adoption. They shall prepare and submit to the council annually a capital improvement plan. And the council, keep the council advised of the financial condition and future needs of the city. Santa Rosa states that not later than January 1st of each year, the council shall publish a summary of the current year's adopted budget. The city manager shall submit a proposed budget for the council for the maintenance and operations and capital improvement plan, capital improvement for all city departments. And prior to adopting the budget, the council shall publish a general summary of the proposed budget. San Bernardino's does, their charter did not state. Visalia, the city manager shall send the council estimate in writing of the amounts required for the business and proper conduct of the various departments, offices, and boards of commission over which he has control during the next ensuing year. And Tulare states that they shall provide a detailed estimate of expenses conducting of each department, expenditures for the corresponding items for the last 2 fiscal years, expenditures of corresponding items for the current fiscal year, and supplies and materials on hand, any other information as the council may require, and any recommendations of the city manager.
Thank you. Anything else? Any questions or comments? Moving on.
So Shafter, we have a section for our emergency appropriations to meet a public emergency affecting life, health, property, or the public peace, the council may take emergency appropriations provided monies are available in unappropriated fund balances. In Anaheim, Hayward, Irvine, Lancaster, Palmdale, Riverside, San Bernardino, Visalia, and Tulare, their charters did not state emergency appropriations. But Santa Rosa's did state that in case of a great public calamity, such as an extraordinary fire, flood, etc., the council may, by a vote of 5/7 of all its members, declare that public interest and necessity demand the immediate expenditure of public money to safeguard life, health, or property, and thereupon may proceed to expend or enter into a contract involving the expenditure of sum required for such emergency.
Any comments or questions?
I'm just curious, how much money do we have in that fund? Does anyone know?
We're in the black.
No, that. I mean, that's specific.
I don't know what our balances are.
So just for clarification, Gerard, you're talking about the emergency
Yeah,
fund
is that a
balance?
specific fund? That's how it reads, or no?
No, so
Okay.
cities will, so as a governmental entity, we don't operate like with profit. But I mean, cities will have what's called as a fund balance, meaning like at the end of the budget year, some cities call it budget surplus, some call it fund balance. And so basically what this is saying, if there's monies that are not appropriated in the fund balance, in other words, there's a couple $1 million available, then that's the monies that can be utilized for emergency appropriations.
Okay, now I just didn't know if it sounded, when she was reading it, it sounded like it was a specific fund. I thought, well, that's interesting, but so it's not. So I just wanted to make sure. So that's fine. So
Next,
Next, we have lapse of appropriations. Every appropriation in chapters charter, I'm sorry, every appropriation except an appropriation for a capital expenditure shall lapse at the close of the fiscal year to the extent that it has not been expended or encumbered. An appropriation for a capital expenditure shall continue in force until expended, revised, or repealed. The purpose of such appropriation shall be deemed abandoned if 3 years without any distribution or encumbrance. So Anaheim, Irvine, Lancaster, and Palmdale's, their charter did not state anything about lapse appropriations, but Hayward stated that all appropriations shall lapse at the end of the fiscal year to the extent that they shall not have been expended or lawfully encumbered. Riverside states that all appropriations shall lapse at the end of the fiscal year, similar to Hayward's as well. Santa Rosa and San Bernardino's charter did not state, and Tulare as well. Visalia states that all appropriations shall lapse at the end of the fiscal year to the extent that they shall not have been expended or lawfully encumbered.
any comments or questions? Moving on.
The next section we have is that debt. Chapters charter states that the city may issue all manner of securities and incur all manner of indebtedness for any municipal purpose, included the construction of all manner of public buildings and facilities. So we have but within the following limits. So we have a general obligation debt limit. The city shall not incur an indebtedness evidenced by general obligation bonds if the principal amount of outstanding general obligation bonds at the time of issuance shall in the aggregate exceed the sum of 10% of the actual cash value of all real property taxable by the city. So Anaheim state that the city shall not incur an indebtedness, excuse me, I feel like I'm saying that word incorrectly, evidenced by general obligation bonds, which shall in the aggregate exceed the sum of 15% of the total assessed valuation for purposes of city taxation of all the real and personal property within the city. No bonded indebtedness shall constitute a general obligation of the city, may be created unless authorized by the affirmative votes of 2/3 of the electors. Hayward states that the city shall not incur an indebtedness evidenced by general obligation bonds, which shall in aggregate exceed the sum of 15%. I believe that's similar to Anaheim's. And Irvine's, Lancaster, and Palmdale's did not state debt information. Riverside's charter states that the council shall not incur an indebtedness evidenced by general obligation bonds in which the aggregate exceed the sum of 15%. No bonded indebtedness which shall constitute a general obligation of the city may be created unless authorized by the affirmative votes of 2/3 of the electors. Santa Rosa's and Tulare did not state in their charter. San Bernardino states that the maximum rate of taxation shall not exceed any 1 year, $1.35 upon each $100 evaluation or property assessed exclusive of the amount necessary to pay the principal of and interest on the bonded indebtedness of the city. Visalia states no indebtedness evidenced by general obligation bonds shall be incurred by the city unless authorized by the affirmative votes of that number of voters voting on the proposition for incurring such indebtedness that shall at the time be required by the Constitution and general laws of the state.
This section right here is very wordy, confusing. Is there a way to maybe streamline the language? We simplify it?
Well, I think there's in all that language, there's formulas so that they don't get carried away and borrow too much money.
Right. What I'm saying though is for the sake of this document, that language can be streamlined to be very simple so that that's exactly what you're reading.
Yeah, but you want to put that on the list?
Yes.
Number 3.
It's actually section 708 and 709 at this point, and there may be more when it comes to all this stuff. It's all kind of together, so I can't see on her screen if there's further section. So maybe just probably section 7.
We can do that. Any other comments or questions? Then let's move on.
Moving on to investments and chapters charter, it states that the city manager shall be responsible for the investment of city funds. The council shall annually adopt an investment policy, annual review by the city auditor. Investment shall at all times be in compliance with all provisions of the laws of the state of California. The city's policy governing investments may be more conservative or restrictive than state law, but in no manner shall the investment policy be less restrictive. Anaheim, Hayward, Irvine, Lancaster, and Palmdale's charters did not state any information for investments. Riverside's charter stated a monthly report on the cash and investments held by the city and all of its departments, offices. They shall receive a monthly report, on the cash and investments held by the city and all of its departments, offices, and agencies. And Santa Rosa, San Bernardino, Visalia, and Tulare did not state investments in their charter.
Thank you. Any questions or comments on that piece? Let's keep going.
So in chapter's charter, we have a miscellaneous fiscal procedures, and it states that the council shall adopt by ordinance, provide for appropriate and necessary financial procedures as far as petty cash, claims and demands, warrants and checks, and any actions against the city. Anaheim, Irvine, Lancaster, and Riverside did not state any financial fiscal procedures in their procedures in their charter. Hayward's did state that they may establish by ordinance such other special funds as it deems necessary for the proper administration of the fiscal affairs of the city. Palmdale's charter states that the city shall have the power to lawfully engage in any enterprise deemed necessary to provide revenues for the general fund or any other fund established by the council. And Tulare states that upon request of the city manager, the council by resolution transfer any part of an unencumbered balance of any appropriation to another purpose or object, or authorize a transfer to be made between items appropriated of the same office or department. Santa Rosa, San Bernardino, and Miscellaneous charter did not state miscellaneous fiscal procedures in their charter.
Any comments on that? Okay, let's move on. We're elections.
So in Chapter's charter, it states that all elections shall be held in accordance with the provisions of the state elections code for holding the municipal elections. So far as that code is not in conflict with the charter. If a conflict exists between the charter and the state law on the issue of elections, the provisions of the charter shall govern. The council may call special elections for such purposes as the council may prescribe. A special election may be held on any date specified by the council. The electors of the city reserve to themselves the powers of initiative and referendum and the recall of elective offices to be exercised in a manner prescribed by state law. So I've listed that in this section 8.01 to refer to that section. Anaheim's election procedures in their charter states that they shall be held in accordance with the provisions of the elections code of the state of California. And all other municipal elections that may be held by authority of this charter or of any law shall be known as special municipal elections. Hayward's states that all elections shall be held with the provisions of the elections code, and I believe all of these are they will be held in accordance with the provisions of the elections code. So Irvine states that they're in accordance with the provisions of the elections code, but any other municipal election shall be known as municipal elections and may be called from time to time by the council. Lancaster's elections procedures state that the power to adopt ordinances establishing procedures, rules, or regulations concerning the city elections and public officials, including but not limited to the qualifications and compensation of elected officials, the method, time of the requirements to hold elections, to fill vacant offices, or for voting by mail, unless in conflict with ordinance adopted by the city, state law regarding elections shall apply. Palmdale states that they have the power to adopt ordinances establishing procedures, and they have the qualifications and compensations of elected officials, method and time requirements to hold elections, to fill vacant offices, and for voting by mail. And they are, unless in conflict with the ordinance adopted by the city, state law regarding elections shall apply. In Palmdale, it states they have the power to adopt ordinances establishing procedures, including but not limited to the qualifications and compensation for elected officials. It's very similar to Lancaster. Oh, I put Palmdale twice. I'm sorry. Riverside, I'll just move on. Riverside states that the elective officers of the city shall consist of a city council of 7 members elected from wards and the mayor elected from the city at large at the times of the manner provided in this charter, who shall serve a term of 4 years and until their respective successors qualify. All elections, in Santa Rosa, all elections shall be held in accordance with the provisions of the elections code. Elections shall be conducted pursuant to election laws of the state as the same relate to municipal elections. San Bernardino's states that they shall be conducted by general law, provided however that the mayor and common council shall have power by ordinance to provide the manner of holding such election. Miscellaneous states that they shall be held on the date prescribed by the, it says education code, but that's supposed to be election code. All other municipal elections that may be held by authority of this charter or the general law shall be known as special municipal elections. And provisions of the state law to apply, the council may by ordinance make further provisions as to the manner of holding and conducting elections. And Tulare states that all elections shall be held and conducted in accordance with the elections code of the state of California.
Any comments or questions on that section? Are we gonna go to the end? How far were we supposed to go today?
Just through this section, elections.
Just, so we're at the end of what we were gonna try to do today?
Yeah, so that leaves us general provisions and charter amendments, transition. So we should be able to wrap up next meeting and possibly even start your discussion on what you want to see. There's 3 items that you, as a commission, have asked to bring back.
Good.
So in terms of timing and schedule, you're right on schedule. So that leaves you you can start having discussion, the meeting of the 7th, and then not the 7th, excuse me, that's our council meeting. The next couple meetings and have a list prepared in time to meet that deadline to submit to council.
So I have, our next meeting is June 6th at 5 o'clock. Is that correct?
Yes.
Okay. Any comments or questions from the committee?
I do have a question.
Yes.
So, like, for example, the section that I mentioned that I think would be a great section to streamline, at least up to this point, would that be something that you expect us to do, or would you help do that, or would you do that yourself, Gabriel, and present that if we decided to get to that point?
So I was going to ask the commission what work you would like to see for those 3 items. There is the item related to the first item was the clause, not the clause, the section, the city manager going from 120 to 180 days. That's pretty straightforward. The other had to do with city attorney being a department head versus appointed by council. Anything on that you want additional research that for myself is me and Henry, our city attorney's office?
I think, well, for me personally, I think it would just be more of like wording for separation, but inclusion. So I think the council members should have a part in that. And I do agree that you should have some oversight for that and in regards to it being a department chair. But a way to still word it where the attorney remains neutral for the residents and for the council members. And, does that make sense?
It does.
I don't think it's a good idea for either the city council members or the city manager to have too much oversight over the attorney, because the attorney is such a powerful puzzle piece that they should be able to not feel any type of pressure from either sides to just give that information. Like, you said, they are, ethical, they're bonded, they should follow the rules. There are policies and procedures, but I guess just a little more, something in writing that just kind of supports that, I guess.
Okay. Yeah, I'll work with Henry, our city attorney. We'll look at a few of these other charters, see what they may have in relation to that, and just bring you some samples for that.
Okay. And then the only other thing that I wrote down was about, obviously presenting the charter to the residents. I mean, I know that it's online, but like I said, I Googled it when they asked me about this, and I didn't really realize that it was there, and it was from 1995. So I think a lot of people don't know about it. And then as far as just, it's very wordy, that little section in 708 and 709. So just maybe just a straight statement that's straight to the point of what it is, that somebody reads it and goes, oh, that's exactly what they're talking about. Cool. And move on.
Okay. Similarly, we'll work the city attorney's office, try to come up with some sample language that captures the existing intent and context without watering it down too much.
Right.
But we can bring forward some samples for the commission, the committee to discuss.
Okay, perfect. Thank you.
Thank you. Any other comments? Then we're adjourned. We'll see you here a couple of weeks.
I'm sorry, can I get a motion, please?
Yes, public comment. Do we have any public comment, I guess? Going once, twice, no public comment. Do we have a motion to adjourn?
I motion to adjourn.
Thank you. Second,
I'll second.
want to do a roll call or unanimous?
Aye.
All in favor, please.
All in
Aye.
favor? Aye, aye. All right. Thanks, everybody.